Thank you for joining us for the Ethics and Social Media CLE webinar. My name is Jennifer Matthew. I am the Director of ADR for Alaris. I do have a couple of housekeeping items I'd like to address before I get to introduce Kathleen McDonald. We do have another webinar coming up on August 22nd. That is being presented by Jay McCauley. He is an attorney and a neutral for Alaris in Kansas City. He will be presenting on the pitfalls awaiting arbitration advisors and advocates and how to avoid them. Essentially, this webinar will identify how advisors and advocates lose advantages for their clients and explain why it's surprisingly easy to do so. And then he's going to suggest simple and sometimes not so simple ways to avoid that. This CLE has been approved for 1.2 hours in Missouri, and I have applied for a credit in Arkansas, so that will be forthcoming. And please check out the Alaris ADR website for more details on webinars for September and beyond. After the webinar has concluded today, you will receive a survey. We are always looking for ways to improve. You will also receive the PowerPoint that Kathleen's presenting today. Thereafter, you will receive a certificate of attendance. Usually that comes within 48 hours of the webinar. This CLE today has been approved for 1.2 Missouri credit hours, including 0.6 ethics hours and 1 hour of ethics in Arkansas. If you are joining us by phone only, please send an email to marketing@alaris.us so we can make sure that you receive your certificate. And lastly, if you have any questions, please feel free to submit them through the Q&A link. Kathleen will leave time as best she can for questions at the end of her presentation. So now it's my pleasure to introduce Kathleen McDonald. I had the pleasure of first meeting Kathleen, I believe it was last year. I knew instantly that she is bright and dedicated. And I'm not saying that just because she's sitting here. So Kathleen is the director of the immigration practice at Wilson and Associates here in Little Rock, where her experience handling employer-sponsored and family-sponsored immigration matters, in addition to providing I-9 compliance training, helps broaden the services available to the firm's corporate and community clients. Prior to joining Wilson, Ms. McDonald served as a deputy prosecuting attorney in the 6th Judicial District of Arkansas for several years. And most recently, she was the managing partner of Beacon Legal Group, where she practiced cyber law in addition to immigration law. So thank you, Kathleen, for taking your time to enlighten us today. I will turn it over to you.
Thank you. And I hope it's incredibly enlightening. I know it will be, especially because of the masterpiece theater music that you were just listening to. I think that automatically makes your IQ go up like at least 5 points, I'm sure. But yes, so as Jennifer said, I'm Kathleen McDonald. And no, I don't currently practice cyber nerdy geek law, but I did in a previous life. And I've always loved the cyber nerdy geeky elements of anything. And I love my IT department at my new firm because it's solid and they're all about security. It's amazing. But so I try to stay on top of cyber and all sorts of related issues as much as I can. I used to call it geek law, and then geeks got it anyway. Please, like she said, feel free to ask questions. If for some reason I go over because I like talking, feel free to email me, and my contact information is somewhere. It's on some of the slides. And if you need to get in touch with me and you can't, then I know that Alaris has my contact information. So I never know with these things exactly what understanding level or whatever the audience is going to be at. So I try to start kind of simply. So to sort of show the differences between the ways that normal people can use the internet and social media, etc., versus the ways that attorneys and paralegals and people who work in this industry can use it. I've made these slides. There's two people on one side, and those are representative of us. And then there's a woman on the other side, and she's Sally. And so Sally is she's our just normal person. Maybe at times she's a little bit like grandparents, perhaps, who don't have a lot of familiarity, perhaps, with the interwebs. And so she does know some things. She knows that Al Gore was the inventor of the internet. He did say that. She knows that there is something called the internet and that people call it many different things. Internet, inner, like the webs, I've heard it called also. And so she's also familiar with social media. And that's actually a really old little explanation of what the different social media, kind of what their uses are, but I always like it because it really is somewhat representative of what you kind of do on those. You're talking about what you're doing or skills that you have or things like that. I also, though, wanted to put this in. When I'm talking about, obviously the title of this is Ethics and Social Media, but really what I'm talking about is applicable to social media, email, your web presence, any sort of cyber stuff that you've got going on. So it can be expanded. So don't think that if I'm talking about something in email, then that's irrelevant to the subject. But so Sally knows social media. She also knows that social media is sometimes a really good way to show how intelligent you are, and how well you've thought through the things that you post. Like this one, it's sort of, it's really reflective sometimes of where people's brains are. There's more, this one where people are saying, hey, that's a really good looking parrot. And of course there's more. There's a lot out there that I couldn't put in this presentation, just because I figured, there's nice people with nice minds, so I didn't really want to. But obviously there's more. We've all seen interesting things that people post. Sometimes we understand them, sometimes we don't. And it's very interesting because it has become such a huge cultural phenomenon and even just saying that makes me feel like I'm a million years old. But it really is. And there have been psychological studies about the fact that people just sort of turn off part of their brain when they get online, because you post things that you are thinking or are anonymous, or that you're not really thinking about at all, that you would never actually say if the person was right here in front of you. You wouldn't. But somehow that wall goes away, and so people just post interesting things. Obviously, there's also, social media is not just for posting stupid things or silly things. It actually can be useful, because how else, really, if we didn't have this sort of connection that we have with everyone in the world, how else are we going to know about some of the events that are going on so incredibly quickly? Where if there's a typhoon on the other side of the globe, immediately when it's happening, there's a site set up where you can go contribute money to it. Obviously, yes, there's all kinds of sites that are set up where it's not going to that, but it's pretty incredible. And I loved when I was in Sydney a few years ago, and just like, yeah, hey mom, what's going on? Just talking on the cell phone, and it's 17 hours ahead. It was just sort of fabulous. So it can be used for good as well. But so what is the difference between us and Sally? Well, just maybe this little building, they do some stuff in there. Obviously, we're in a profession, and even if we're in various professions, but even if you don't specifically have to abide by a particular set of rules, like our rules of professional conduct in our states, even if those don't directly govern what you do, there's still a lot of things that there's a lot of best practices and a lot of things to think about. So that's why this is open also, not just for CLE for attorneys, it's really for anybody who is going to come into contact with the internet. So basically everybody. And putting in a very more work-specific context, everybody uses it. So everyone who you work with, everyone who you represent, everyone who you are perhaps going to be going against in court or something like that, everybody uses it. So it is something that has become basically a necessity to be somewhat familiar with. And I mean, everyone else is doing it, so of course you need to. But no, we really, really are specifically required to know about it. And thank you, Jennifer, for adding all the Missouri law that's in here, because I'm not familiar with it. But we have to keep abreast of what's going on, because it's very relevant to the practice of our law. It's not just, oh, well, that's a cool thing going on, maybe that would be helpful. We have to know. And it's not just that we have to stay up with how the specific laws are changing in whichever practice area we're in. We have to know about how the changes are in the practice of the law, of maybe how we get information, how we find information about our clients, etc. So, but don't worry, because you don't have to be an expert in it. You have to know enough. I say you have to know enough to know when you need to call in somebody else. Know enough to not be surprised by terms, perhaps. Not all of the acronyms, but know what's going on. And like, essentially, perhaps that email isn't a physical item. If you print it out, it's the paper that's the physical item. But anyway, so oh gosh, I'm sorry. I tried to get rid of all of the little transitions that were in here. I didn't. And now, okay, I think that's it. Basically, what it means to understand, to at least have some sort of kind of working knowledge of internet and what's going on, means this is what you need to understand. Understand the benefits of using it, understand the risks of using it, understand how you can use it ethically and how you can keep yourself out of trouble, ideally, of all of the social media, the internet, websites, all that stuff that we're talking about. I'm sorry. I promise. I didn't really want to do that part. Okay, so what are these? What do we use the internet for? What do we use all of this for? Yes, it is to post dog photos and cute cat playing the piano videos. But also, we can use the internet, the interwebs, for very work-specific and very valid reasons. Obviously, we can use it to research and investigate things, to advertise. We can use it for multiple purposes. So, we all know Westlaw and LexisNexis. We learn about it. I had a law school professor who hammered into our brains, you never know when the internet is going to go away and you're just not going to be able to use it anymore. So you have to know how to use these online, but also be able to use the books. I totally agree. I love the books. I love the smell of libraries, but Westlaw and LexisNexis are extremely useful online. They just are. And if you've got Fastcase and other tools like that, I don't really know how people survive without some sort of mechanism that they can search things in. And to talk specifically about that, Google and Bing. And I put Bing up there mostly because I try to be nice and equal opportunity, but it's very few. It has so little market presence right now. But Google, of course, has become one of the things that we turned it into a verb, to Google something. And it's become so important that we almost have a duty to Google. If you don't Google your clients, if you practice family law and you handle divorces and domestic issues, if you're not Googling your clients to just see what pops up, some states are getting towards where that's malpractice if you don't do that. And something that would have been easily discoverable pops up and could have been used had one just done that, because it's so easy to do and because pretty much everyone has some sort of access to be able to do it. And of course, I put the little Dilbert cartoon because it's funny to me. All right. This is a part that's annoying to me when I'm doing webinars because I can't say, raise your hands if, but raise your hands at home if you know about the Wayback Machine. I love the Wayback Machine because what it does is it has bots, and its little bots crawl the internet and basically take sort of pictures of websites at various times. And so what you can do, and they've been doing this for years, what you can do is you can type in a URL into the little search field right there, and it will see if its bots have ever captured that website. And if it has, then it kind of brings up a calendar. And sometimes it goes back 20 years. And you can click on, say, June 5th. And so you can click on there and you'll see what that website looked like on June 5th. Yes, it can be sometimes funny because you can see people's horrible old websites, but it also has a valid, useful function. Let's say that the person who's you're suing because they libeled your client or because they stole intellectual property or something like that. Let's say that they had stolen the intellectual property, put it on their website. Now, though, of course, that they've been figured out, they've changed the website so that you can't see that. Well, maybe the Wayback Machine has crawled it, and you could basically pull the website as it was on whatever the day is that it captured it. Granted, you would need some sort of another geek/nerd to be able to get that evidence and preserve the evidence and all that. But you can see, maybe they've actually got that, and I've used that in cases. It's sort of fun. So here's some examples. This one from over 2 decades ago, back when Google was going, we have over 25 million pages indexed. Yes, of course, it's slightly larger than that now. This is McDonald's from back, and I'm sorry you can't see that, from the January of 1997. They did have a website at that time. Some people don't. Sometimes you'll type in the URL and you just won't find anything because they didn't have it, but whatever. All right. Also, you can use the interwebs to do traditional discovery. You want to, if you have a practice where you're using interrogatories, requests for production, those sorts of things, you should probably, if it's relevant, you should probably be asking for the login names of whichever social media the person uses, or if they use it, or you want to see, because a lot of people, and I'll talk about this later, there's privacy settings so that so some people can see something, some people can't. Don't ask in subpoenas, don't ask for their passwords, or in discovery or any of these. Don't ask for passwords because it's really, nowadays, it's just not necessary for a lot of the social media. They sound old, the social media. Because even Facebook has a feature where you can just do a few clicks and get your entire Facebook history. And so you could turn that over. Obviously, they pay us the big bucks so that we can argue about what pieces of that the other side should be able to have. But if it's any kind of divorce case, something like 75% of divorces nowadays have some sort of social media evidence. I mean, because people stop thinking about it and they don't think, oh, when I post this photo of me with my new boyfriend, even though I'm, still married, that might actually be useful someday, and not just so that you and your perhaps children will be able to see it and reminisce with you. Oh yes, and so like I said, don't ask for that. But the reason that we can use that is that's going to be highly relevant. Sometimes, obviously, if there's nothing there, there's nothing there. But it can absolutely provide some sort of useful information. How many? Okay, I'm going to pick on the people who are actually here. How many different social media can you name? Like, obviously, I've talked about Facebook. Anyone? Twitter, Instagram. What are the kids calling that nowadays? Either Insta, but I think that's old, and now it's IG. Yeah. Snapchat total. Have you heard of TikTok? Okay. Yes. There's tons. And that graphic even is old. But there's so many, and they're for very different purposes. And there's new social media basically every day. And a lot of it gets popular and not popular very quickly. Some of it actually stays. Like Instagram, they've actually been around for a while. And I would bet that they're kind of they're probably on the down slope of their popularity because there's so many that are taking its place and they've got better uses. And so anywho, I just think that's funny too. There's tons. And if you're if you like to make really obnoxiously long interrogatories like I do, or requests for production, you can just like do a search and just see how many you can find and stick them in there and say, if you've got any of these, then, which is part of why I put it in really small font. But don't forget about spoliation issues. So that person who stole your client's intellectual property and then changed their website because they're like, ooh, I probably shouldn't have this on there anymore, they're getting rid of evidence. So you have to know enough about the interwebs and how it works to, one, tell your client that they need to not just be taking stuff off because they're possibly getting rid of evidence. And also you need to know enough to, as soon as possible, send that letter that not only says, keep all of the papers and anything relevant to this possible this possible lawsuit. That means electronic as well. And so people need to have a plan for that. A lot of companies have automatic things set up so that after 30 days, this is wiped off the server because you only want to, store so much. But those companies that have those sorts of things set up, and even if they don't, they still need to know if they get that sort of warning, what are they going to do about it? Do they know to go to IT and say, hey, we got this, so you need to make sure that all this doesn't happen, that this is actually being preserved, and in what fashion, and all that sort of thing. So make sure that if you represent companies, that's somewhere in your brain, because that's going to have to happen. You don't want to get penalized for doing it. You don't want to affect your client's case. Ignorance is actually not an excuse anymore, because there is enough knowledge out there floating around that you should know that you have to do at least something like that. And I will discuss other trial-related issues later. Oh, Lord. All right. So another way, obviously, that we use social media and the interwebs is to advertise. And so keep that in your brain, because you need to know the rules. You need to keep in mind that if you're saying it just on your Facebook wall, that other people are seeing it. That's sort of the point of putting something on your Facebook wall, is so that other people will see it. I generally really don't care about what you had for breakfast this morning, but some people think that people care. So know the rules and follow the rules. And it's honestly not that, it takes a bit of adjusting in your brain, but the rules are the rules regardless of what it is that you're posting on. If back in the day you published on the back of a phone book, and you know that you wouldn't say in that ad, I am the best immigration lawyer in the world, and I guarantee you that your petitions to USCIS will always get approved, then you have not been living in the world I have been living in, because it's slightly harder. We know that we're not going to make those kinds of claims. We can't say I win 100% of my cases. You may, but that creates all kinds of thoughts and expectations in the brains of clients, potential clients, and so you can't say it. So if you know that you can't say it on the back of a phone book ad, it's the exact same thing for a tweet. It's the exact same thing for what you put on your law firm's website. It's the exact same thing. It is still something that you are writing and that you are putting out there, and it can be used to get you business. It can be used also to get you in trouble. So be aware of what you can say and how you can say it. Because really anything is an ad. Even if it's the Facebook page for your firm and not your personal Facebook page, if you are posting something out there that you're not supposed to say, you're probably not supposed to say that. And I'll talk later about different privacy settings. So it's actually also kind of interesting to me because with the internet and basically having the entire world in our cell phone now, so many things have changed, and it's not just, oh, hey, I can go watch what's going on in, the World Cup that's somewhere else very easily. It's changed advertising. And there's social media advertising is a huge industry that it wasn't 20 years ago. I mean, 30 years ago, nobody would have known what you were talking about. And so it's changed in such huge ways, so many sectors, that it's changed, obviously, our rules also, and how we can do things. But any of those rules, when you actually sit down and think about it, it's the same rules that we've always had. It just has different effects on different things. So be aware that everybody is on the internet. That means that your boss, if you have a boss, your boss is probably on the internet, probably on social media. If you guys are Facebook friends, cool, but just be aware. And if you're saying, oh, I just can't come in today, and then you're like, oh man, having an awesome day in the backyard, drinking my mimosa, your boss may see that and she'd be like, okay, next time you ask for some time off, that may not be so easy. Also, your jury pool is going to be on the internet as well. And we live in not the largest city. And so when you pull out of your driveway and nearly crash into somebody, that might be the person in your jury pool. And that person may then be like, oh man, he was a bad word today. And they might start posting about it too. And if you post, oh man, I wish ladies would drive better, because no one's ever posted that. That might be the person, it could be just your luck. That's the person that you shouldn't have posted about that. And she'll know that you were talking about her. If you're a judge, also be aware. Don't forget, your judge is also most likely on social media. And so if you call and try to get a continuance of a hearing that you've got, and then of course you're posting with your Bloody Marys, again, maybe you won't get that continuance the next time you ask for it, because judge might not really believe you anymore. But just as we have our rules of professional conduct, judges have even more rules that they have to abide by because they're in an even more special position. California is all about any sort of techie, of course, anything that's going on. And so their attorney rules cover and specifically address a lot of the internet and electronic media and everything related issues. They, of course, remind us that judges are people too. And so judges need to be able to have Facebook pages. Some states have specifically talked about like being Facebook friends with a judge. And does that create some sort of bias? Is that going to mean that the judge wouldn't be able to be fair to that person? If I'm not a Facebook friend of the judge, but the opposing counsel is, does that mean that opposing counsel has one up on me? I mean, there are valid concerns. Most of the states, those have specifically come down on the side of it creates no more impropriety necessarily than being neighbors is necessarily going to, or being in organizations together. If there's going to be impropriety, there's going to be impropriety, but just the fact of being a Facebook friend or something like that is not necessarily it. But that's not every state. So be sure that you look at your own rules. If you're an attorney in Arkansas, you may recognize this person. This person was a judge, and this person was on it was a chat group back in the day that we had chat groups, and it was an LSU online fan forum. It was, I can't remember, Tiger something, I can't remember. Tiger Droppings. Thanks. Thank you. And so he made these are just some of the things that he posted. These are the ones that are slightly less racy and slightly less offensive. And so, but the issue was, is that okay for him to do? Is it just free speech? What if he doesn't say that he's a judge on it? You know, maybe he just acts like he's a normal person on it. Well, yeah, but extrajudicial conduct is still very relevant to whether or not that person is following their particular guidelines. You may or may not know that he's like still in prison, right? Yeah. There's a lot I didn't put on there. Oh yeah, well I did put some about other pieces that he, seriously, I promise, Alaris, these were not the worst. So this was my judgment. So anywho, client endorsements and testimonials, etc. We have different rules, the different states do. And we can say, sometimes we can say things, sometimes we can't. Sometimes if we say things, we have to put a little disclaimer down there that yes, this person was paid. So check your rules. Anything that I say today, check your rules, because that's always the best thing, go to the source. But we have to be very careful about that. And the Arkansas rules basically say, you can't make some of these statements. For decades, of course, attorneys have been on one side of this argument and attorneys have been on the other side. And some attorneys are of the mind that as long as you disclose what's going on or who the person is or the fact that you've paid them, it should be fine. Some are of the mind that it doesn't matter. Like if they're an actor, then they're just talking about falsehoods. And so how is that something that's acceptable? I do know, excuse me, specifically that we've got people who are involved in working on the rules. I would be surprised if it doesn't change sometime soonish, our specific rule about this. So that's why I put on, but maybe not for long. Just depends on how you define long. Sorry. How the heck did I do that? So here's Missouri's rules, different from our own. So beware, and don't forget that if it's a commercial that you're planning to send to be on NBC or whatever the local affiliate is, if you then put that on your YouTube channel, the rules are the rules. And so it's not like, okay, well, let's cut out these parts for when we put it on, when it's gonna run on television, and then we can just do whatever, like the uncut version on YouTube. If you are a lawyer and you're licensed here, you have to abide by the rules, and the rules are the rules. So, profiles on LinkedIn. If you have a LinkedIn profile, and I'm not gonna ask for people to raise their hand, I haven't. LinkedIn started as a one-size-fits-all professionals. Facebook was the fun and kind of casual way of networking or being socially connected to people. LinkedIn was the more professional one. This is where I post, you know, my resume, or if I'm looking for a job, or here's my skills. And so back when it began, like I said, it was kind of one size fits all. And so it had areas of practice. It's perfectly fine for a doctor to say, I specialize in X. Or okay, I just realized I can't say that for sure because I haven't actually looked at their code, but it's not a humongous deal. They get board certified. They don't have to, but they can vary, not easily, because they have to take tests every single year, obviously, to be certified in a particular specialty. But they can say that, and it is not incredibly rare to be a board certified physician in whatever specific practice. Here, depending on the state that you're in, you may not have more than one or two. In Arkansas, we have two. And so if you say that you're a board certified immigration attorney, personal injury attorney, woohoo, that will immediately get you in trouble. And so the way that it links back to LinkedIn is that they would ask, what are your specific areas that you work in? But they put it under a header that said specialties, which isn't necessarily a huge deal, except for the states in which you can't really say, I specialize in this, or else that implies that there is some sort of a test that is available, that once you take it, then you may say that you are. Tax, yeah. And I stay away from tax. But if I had actually passed that part, yeah, I would say I specialize in that. So it can have issues. They obviously got enough complaints or maybe threatened, people being very unhappy with how they did it, but they've changed it. They've changed what they said. They also allow client testimonials. You can endorse a person for a particular area. You need to be careful about those too. You could have a parent who's trying to be really nice and helpful and is proud of everything that you've done, who goes, yes, my baby, and that's not what my mom sounds like either, but my baby is great at tax law and immigration law and personal injury and debtor creditor and collections. You may do none of those, but if those are all clicked and you let those stay up there, you're condoning them. So you also have a responsibility to look. Just because someone else put it up there, it's not an excuse. I have not seen a case that specifically says if it is up there for longer than 48 hours, then that means that you are condoning it. But if it's a judgment call. And so if you leave that stuff on there, you've obviously been on your page for a while and you've done other adjustments to it. If you leave that on there, you're condoning it. So be aware of that. And yes, Jennifer has a question.
So it's from, I'm just going to ask it now if that's okay, because
yeah.
I think you basically answered it, but
Okay.
One of our attendees asked, are LinkedIn endorsements from other members treated as advertisements?
Oh,
I
yeah.
believe you just answered that, but
Yeah.
that's the question.
Yeah, and it doesn't matter who it's from, but yeah. So again, if someone tries to say that I am awesome at tax law, like that's the fastest one that I will run away from. I intentionally did not get into any of the financial areas, which is funny because the majority of what my current firm does is financial related and like real estate related. Yeah, no, I don't. They're awesome. I know none of that. So I do the international thing. I don't know why it goes in that fashion. Be careful who you friend. Be careful who your assistant, your staff, whoever it is who you friend. If you're a court reporter, if you're a paralegal, doesn't matter. If you are sending friend requests to potential jurors, that can get you in a lot of hot water. Don't think that just because you said who you were and you weren't like using a false name or something like that, that doesn't make it safe. Don't do it. Don't forget also that if you have specific social media for, let's say, your firm, you need to make sure that you know exactly who it is who has access to that, and be aware of, don't let it just be one person. but don't let it be everybody. If you let it be everybody, you can't control your message, which obviously isn't good marketing anyway. But also, if that person leaves, it may be that they leave on a bad note. And if they're the one who's in charge of what your website says or what your social media page says, that might just be a really fun field day for them. So know how to change the password and know who it is who is actually doing that. And even if they don't leave on a bad note, still, it's a good practice. Okay, so segue alert. Moving to what can and cannot be done at trial. Because there's so many rules, there's so many more rules about what we can't do, obviously, than what we can, so. Okay, outside information coming in. Big issues. I mean, it's basically the whole reason, well, that's not the whole reason we have judges, but obviously that's one of a judge's huge roles, is to decide what can come in, what the jury can listen to, and how and which parts of it. So we've got huge issues. And keep in mind that everyone has the internet in their hand, and people are interested. And they don't necessarily do it because they know that we're limiting what they can see, and they want to see the real honest truth. Sometimes it's just like, oh, hey, boy, that lawyer, I feel like I know her. What? Oh, that's her name, and they'll look it up. I mean, they can look up all kinds of information. When they're sitting in there and they're potential jurors, they're gonna know what the name of the case is. They may look people up. And so be aware of it. It's become an issue in more and more courts, even though judges, provide the admonishments every single time that they take a break, and they remind, don't go on the internet. Don't discuss this with your fellow jurors. Don't use your phone and look stuff up. Don't post about it. So obviously we've got some of these issues. And there are sometimes that bits of this are okay, sometimes that they're not. You can generally, most states have basically said, it's okay to look up juror information. Of course, there's exceptions. Whatever's out there that anyone could get to, if it's publicly available, then you can look at it. Because the whole point of having voir dire, AKA voir dire, is that you talk with them and you see if anyone has a bias that is not going to be good for your client. And this can uncover information that wouldn't necessarily come up in the average, if you're at a robbery case or car accident case. So, and people get paid a lot of money to be the experts on picking a perfect jury. And so it's not just, anymore, it's not just, okay, well, let's see if she wears flats or wears heels when she's coming to report for jury duty. Let's see which magazines she's bringing with her as she waits to be called. Let's see what television shows she really likes. Is it ER or is it Law and Order? It's not just that anymore. It's who does this potential juror like on his Facebook page? Does he like the NRA and guns and I don't know, country music? I'm trying to think of stereotypes. Don't get mad. So whatever information that's going to convey to someone, whatever assumptions they're going to make about that provides some sort of information. Or do they like all kinds of green stuff, and the people who go out and protect the whales and are voting for the third party candidate? That can provide some sort of information. It could be that that's an assumption that's entirely not accurate, but still that is some sort of information that wouldn't necessarily be revealed when you're talking with them. So you can look at that. You can look at their tweets if they're just all out there. Look at whichever it is. But you have to know social media well enough to know that if you try to access their personal page, the personal stuff, if they've got any sort of, you have to be their friend to access da-da-da-da-da. If you send them a friend request, bad, bad, bad. That is directly accessing them. That is going up once the jury's been picked and said, hey, so where'd you go for breakfast today? It doesn't matter if you have no ill purpose. I had a judge who, when we would take breaks, he would say, we live in the South and we all like to be nice Southern people. And so I always say good morning to people. They always say good morning back. If the lawyers don't do that to you, don't assume that it's because they're being rude. They're doing it because they're following my rule that they need to not have communication with you. So even with those, it doesn't matter necessarily what your intent is, it matters that it happened. Know that if you use LinkedIn and you just look at a person's profile, it's going to send them information that you looked. That, even though you didn't technically even try specifically to contact them, that's contact. And lawyers have gotten in trouble for that. So you need to know that technologically, that is what happens, unless you've got, I think, like the paid version of it, and then it doesn't necessarily do it automatically. And it's not the only side that does that. Inside information going out. This is another big area where jurors and attorneys and judges all get in trouble. Jurors posting about the case, big issue. These are just, it's probably every single state that something has happened in. These are just a few that I choose. West Virginia, and if there's anyone in here from West Virginia, I'm very sorry, and it's a beautiful state. And I like some of the songs that are about it. I don't always think about it being the technological forefront. However, it was one of the first states that had some sort of actual response to jurors doing something on social media that they weren't allowed to do. What happened was one of the jurors was MySpace friends, yeah, MySpace, with the defendant, didn't reveal that when the question was asked, does anybody know any of the parties involved? And contacted the defendant and said, hey man, I'm really pulling for you. And that was not kosher. That was not very cool to do. And so the judge in that case set aside the conviction and they had to start over. Michigan was one of the states, oh yeah, where two jurors nearly caused a mistrial in a homicide case because they made Facebook comments about what was going on. They said, and then yes, another juror said, it's really gonna be fun to convict this guy. So the judge in that case replaced one of the jurors with an alternate. And another one, he fined $250 and made the juror write an essay, a 5-page essay about the importance of the right to a fair trial. So I like that one. Alternative sanctions, anyone? Then right here in Little Rock, Arkansas, we had one a few years ago, where it was a rape and kidnapping trial. So this is not just like a theft of candy bars from Kmart. Yes, Kmart. This was a kidnapping and rape trial. And the judge, every single time there was a break, said all of the standard things, don't talk to each other, don't post on social media, all of that. Side note, if you're a judge, or if you are in court, you may want to ask your judge to do this. It's always good to have some sort of explanation for the jurors as to why they're being limited, as to why you're telling them they can't do something. So it's not just because we want to be obnoxious and not have you post stuff. Tell them why. Talk about the actual right to a fair trial and why that's important. Talk about how their posts can mess things up and why, and the reason that they're being asked not to do something. Courts that have done that and have tried to make it more clear have had a better, probably a lower rate of incidents, but of course it happens everywhere. And again, you go on social media and your brain turns off. So, but in Little Rock, at this trial, it was after the defendant had been found guilty. I think it was before sentencing. And one of the attorneys on the case was just looking around and found that one of the jurors had posted during the trial about the trial. So brought the juror in, and the juror, it came out that yes, that was in fact the juror's post. And that juror got convicted of misdemeanor contempt of court, had to, I think they got fined some amount, I don't remember. Other things happened afterwards. But that defendant the conviction was overturned. So think about all of the tax dollars wasted, all of the time wasted on both sides, just because that juror couldn't stop themselves from posting something about it. Oh Lord, 8 minutes. Okay, cheers. So, Florida, God love Florida. Florida had one where there were, oh yeah, they've got some rules where a juror could have gotten like 6 months in jail for having posted about some stuff. These people didn't. It may have happened afterwards. One of the jurors, though, however, in one of the trials, got led out of the courtroom in handcuffs, so that for just posting about the case. So you don't want it to happen. Oh, and going to this again, I'm gonna have to change that. Obviously, we use social media to communicate. So beware of how it is that you're communicating. Sometimes you can communicate in not only funny ways, and ways that introduce or put your product in front of people who might not necessarily have seen it. Regardless of how you feel about either of these, it was funny, maybe not even funny, but it definitely was press. It definitely got both of those companies in front and in people's minds that it would not necessarily have if this transaction on the internet had not just happened. I like this one, girl power. Thank you very much. Female empowerment. There's apparently a long story though about this particular tweet. I think this is funny as well. The evolution of types of communication. Oh my Lord. If anyone has seen one of these commercials it was a Super Bowl ad. He paid $2 million, maybe, I can't actually even remember. But it was a national ad during the Super Bowl from a lawyer. And so it was seen by millions of people, just of course when it was aired. Then people were talking about it, and so it's been seen millions of times on YouTube. So it can have a huge, huge reach. And this one is actually interesting to me because I do sometimes have to think, okay, wait, so how many hours ahead or behind is the person that I'm talking with on the phone? And sometimes it's not clear at all. Like, okay, wait, which island is it though? And so is this one. Okay, again, etc. This is the etc. miscellaneous area. So have good security. In your law office, you probably lock the door. You probably have a filing cabinet. I like digital electronic. I can yell. Hi, how's it going? Okay, cheers. All right, so even faster. If you have anything, lock it up. You wouldn't leave your office unlocked. You would, if you've got a filing cabinet, well, you probably don't lock it, but you would lock your office door. You put a password on your computer. You don't put that password on a sticky note on your monitor. Don't do that. I know everyone does that, but don't do it. Because if someone is trying to get in, yes, they will. Hi, can you hear me? And I'm talking now, and I'm gonna hold it like something or so. No, okay, cheers. Don't write your sticky note, don't write your password on a sticky note. Also, don't make your password be password, or 1234, or God. I think it's a university that every year puts out the most popular passwords. Constantly, those are at the top of the list. So if someone's trying to get into your computer, your account, whatever, if it's that, it's very likely that it'll get figured out. There are programs that hackers use that are basically dictionary programs. And so it runs a whole bunch of words really, really quickly. And so if you're using a word, then that was not very creative and not very secure. And 12345, not much better than 1234, just so you know. So don't write it on a sticky note, have a better password. We have to pay, in my firm, we have to change our passwords every 30 days, which I'm totally okay with that. Slightly annoying in the beginning, but I'm really okay with that. And it makes everything more secure. I'm cool. Media have some sort of, did it die again? Someone's hacking into it. Use my phone. Hello? Hello? Can you hear me? No? If I knew sign language, I would totally do it. Okay, how many minutes? 3 minutes. Okay, all of the social media have privacy settings. Check them out. And check them out again because they change. And Facebook has gotten in trouble for that. Main thing to remember, the rules are the rules, regardless of the medium. If you wouldn't be walking around and leave your folder of 3x5 printed out photographs in front of the jury, then don't leave a flash drive where somebody can easily get it. Don't have all your storage behind a wall that is where the password is password. Just think about it, and because pictures are pictures, and if someone needs to not be able to access it, they need to not access it. Also keep in mind, however, you could be doing every single thing perfectly and nothing is 100% secure. You're gonna make a mistake. You're going to type in the K in Outlook to send it to Kathleen, but it'll actually go to the other Kathleen because you just weren't paying attention, or it goes to the Catherine or whatever it is. Maybe you're clicking reply all, and you probably shouldn't be clicking reply all. Pay attention, don't let your brain turn off. Nothing is 100% secure, and it sort of seems like, please, would you do it forward? Anything? No, okay, oh my God. So, that works, thanks. Anything that you send can be forwarded very easily. So even if you just send it to one person, it can be sent to everybody. Just know that. Everything can be taken out of context. If you're trying to have a very serious discussion over text, probably not the best idea because you just can't convey all that information. And it can live forever. When you're trying to get information from a computer, that's when you can't get it. When you don't want it to be able to be found, that's when you do find it. And just because you think that you are taking your computer to people who say that they're experts to get stuff off, they're not necessarily. And so if you're trying to get evidence, sometimes you need to not just go to the easiest big box store to get it. Also, people make mistakes. like tweeting things and they meant to direct tweet it or whatever. Sometimes they send it to people they didn't really intend to, but then it makes for all kinds of really fun sort of information. Here's Arkansas rules and Missouri rules. And technology is good. And I love those. And there. And I'm done. So please send questions. If you send messages to Jennifer, then she will forward them to me, and any other questions? Thank you. This concludes the webinar. Chickadee check. Check.